with this esteemed group here, let's talk a little bit about this big news. We know that the FTC has indicated it's interested in some rulemaking around what it's calling commercial surveillance, which I thought was an interesting term in itself. Maneesha, why don't you kick us off? Is this big news? And if so, why?
This is really big news. It is a big milestone for the FTC that's been years in coming. So if you think back, you have Commissioner Slaughter, who's been calling for a rulemaking for years. And even before that, I think there have been some folks calling for the FTC to use this authority that it has called MAG-MOS rulemaking. It's not APA, notice and comment rulemaking. It's a much more involved type of rulemaking, but you have a lot of stakeholders who've been calling for the FTC to do this for many years. I think there's been a debate. I think there's some people who say these MAG-MOS rulemakings take forever. They take an average of 5 to 6 years. Technology moves too fast. It's not a good tool to use for rulemaking. And then on the other hand, you have people saying, hey, if we had done this 6, 7 years ago, or 10 years ago when we started looking at these issues, we could have had a rule by now. So I think that's the debate that's been going on. And I think the fact that they put out an advance notice of proposed rulemaking has put an end to that debate. So the FTC is in the thick of it. It's kicking off this rulemaking. The rulemaking could have a really profound impact on companies, changing the rules of the road for a lot of sectors in the economy. And so I think it's quite big for the FTC and any stakeholders involved in privacy.
Maneesha, tell us at a high level, if you could, what is this MAG-MOS rulemaking?
Sure. So typically agencies issue rules under APA rulemaking, Administrative Procedures Act rulemaking, which is typically just you put out a notice, you get comments, and you issue a final rule. And the FTC has been able to do that within 6 months to a year. But then back in the 70s and 80s, you had some concerns, or legislators had some concerns about the FTC going too far with their rulemaking. And so they clipped the wings of the FTC somewhat, and they imposed all these additional procedures in addition to notice and comment. So for example, the FTC has to do an advance notice of proposed rulemaking. In addition to the notice of proposed rulemaking, if there are disputed issues of material fact, there can be a hearing. There has to be a presiding officer. There has to be cross-examinations. The presiding officer has to do a report. There have to be petitions for exceptions to the rule. And so with the result, instead of a process taking 6 months to 12 months, the process can take 5 to 6 years.
Which is sort of difficult, right? Because, as we know, technology moves fast, and so it sort of handcuffs the FTC, especially at a time where we hear a lot of chatter about the FTC needs to be more powerful, it needs more tools, it needs to be able to move with agility, right?
That's exactly right. And I think that's been some of the criticism of the use of this MAG-MOS procedure. I think the other thing I would note about MAG-MOS and this rule is that the FTC can't just be a roving regulator declaring practices to be unlawful. They have to fit within a specific rubric. So the FTC has to show that the practice is either unfair or deceptive, and that the practice is prevalent in the marketplace. And so that's a really tough hurdle for the FTC. And so I think one of the things they're going to try to do is to get comments to try to build that record that the practices are unfair, deceptive, and prevalent in the marketplace.
And it seems like, go ahead, Gabe.
Oh, I want to pull on a couple threads that Maneesha started pointing out, just to highlight why this is such a big deal. So for years now, the FTC has proceeded in privacy and security on a case-by-case basis. And it has done so under its unfairness and deception authority, sort of carefully weighing practices of specific companies to identify practices that deceived consumers or were unfair and met this balancing test, that they weren't outweighed by countervailing benefits to competition. And it's been a sort of piece-by-piece approach that has moved market practice, but has often left companies guessing as to what the sort of forward-looking rules of the road are, and has also, some would argue, left the FTC with fewer tools to pursue norms in the privacy space that are similar to what we see in Europe or are starting to develop in the States. So this is huge news because we're talking about potential national regulations that would codify, that could codify some of what the FTC has done and could extend way beyond that to, given the scope of the questions that they're consulting on, to practices that the FTC hasn't touched on. And even beyond that, Maneesha mentioned the FTC having its wings clipped in the 70s. There's this story that the FTC tried to pass rules around television advertising to kids. It wanted to ban it. The Washington Post ran an editorial that called the FTC the national nanny. And this was a turning point for the FTC. It had its authorities in rulemaking revoked, and there are theories that the FTC has been more cautious in its approach since then. So I think what we're seeing, last week with this announcement is a pretty profound change at the fundamental level in terms of how the agency sort of conceives of itself and its role in regulating the economy. It's sort of shirking off the legacies of this national nanny critique and is more prepared to step into the fray with affirmative rules rather than proceeding on the piecemeal approach.
Yeah, and I'd like to pick up on that because I think that one of the precipitating factors for this rule was the FTC's loss in AMG last year, where the Supreme Court said that the FTC could not seek monetary redress for consumers. And so one of the things that if this rule is finalized, it would do is to give the FTC the authority to seek civil penalties for first-time violations of the FTC Act. And so that would be a game changer. So right now, companies get one bite at the apple if they engage in unfair or deceptive practices and they're subject to an enforcement action. But under the rule, if finalized, then the FTC would be able to get civil penalties for first-time violations.
One thing that I thought, as I mentioned at the top of the show, was interesting is just the way that they phrase this, calling it commercial surveillance, the fact that they're using the term surveillance. And I also think it's interesting right now that we have, first of all, we have Lina Khan at the helm of the FTC, and we know that she's very interested in cracking down on tech companies' missteps and unfair practices to consumers in kind of new and nuanced ways that we may not have laws to regulate yet. But we also now have Alvaro Bedoya, who has a long history of trying to do his part to combat unfair, surreptitious surveillance, especially during his tenure at Georgetown Law, where he established the, I'll fudge the name probably, but the Law and Tech Privacy Center, something like that. I'm so sorry, Alvaro, if you ever happen to listen to this. I attended many a conference there where he had really thoughtful folks come and talk about the ways that especially vulnerable populations are unfairly impacted by surveillance, sometimes commercial and sometimes otherwise. And so I do think it's an interesting time to be tackling this, and I think it'll be really fascinating to watch his expertise come to play here. Jason, I saw privacy Twitter, TM, go crazy when this whole story broke that the FTC announced it was going to engage in this. Why do you think Twitter went crazy, and do you think it's significant as I do that they're using this phrase, commercial surveillance?
Yeah. My initial reaction was surprised that there was so much hoopla over kind of one loaded term. But I think to pull the camera back a bit here, a month and a half ago, the privacy community was incredibly optimistic, or more optimistic than ever, about the prospect of federal legislation. And really where the conversation was can we get, we've got 3 key policymakers on board. Can we get Senator Cantwell on board? Can we get that 4th key kind of bipartisan policymaker bought in, right? And so I think sometimes that conversation from a month and a half ago sort of got everyone with a little bit of rose-colored glasses about sort of, there's a lot of common ground here. There's just a couple issues separating us: preemption, private right of action. If we can solve those, we can solve everything. I think what this ANPRM, and I'm going to stick with ANPRM, not ANPR. That's my hobby horse, Angelique.
There's been some controversy over the acronym. Yeah.
My take is, this really shows in stark relief how little common ground there is. On one side of the ledger, when you look at the CPRA regulations coming out of the CPPA led by Ashkan Soltani, they are 90% focused on DSAR and privacy policies and opt-out signals. These ANPRM questions are 90% focused on everything else, right? So within the left, there's a real divergence, sort of a philosophy about what deserves attention. At the same time, on the right, we long heard that really the one sticking point was preemption and was private right of action. Obviously, the FTC cannot create a private right of action regime out of thin air, right? But Commissioner Phillips' dissent, took real qualms, not with even the ideas that Chair Khan was going to propose, but with the idea of lumping together data security regs and privacy regs, and basically had concerns that the word surveillance was not a nice word. And so that kind of sort of etiquette squabble tells me that there's actually deeper issues going on, that sort of maybe preemption and private right of action were sort of easy excuses for why we couldn't get agreement until now.
Right. Okay. So I want to respond to what Jason said, and I want to respond to your question, Angelique, with a couple of points. First, I think on ADPPA, there was a lot of bipartisan support. And I don't think that's ephemeral. So if you look at Christine Wilson's dissent, she talked about the fact that the legislature, and I think Commissioner Phillips talked about this too, that the legislature is the right body to do this. So I think Christine Wilson actually said that she supported many elements of the ADPPA. And so I think the tussle here is over kind of the FTC's appropriate role in rulemaking. And so I think that was a big theme that emerged from the dissenting statements. Angelique, you made the point second about Alvaro coming on board. And I think you can see a lot of his influence in the ANPRM. Questions about civil rights, questions about children's and teens, questions about algorithms and the effects on English speaking and non-English speaking populations. I think that a lot of that is Alvaro's influence. So I did want to make that point. And then finally, on the question of the term commercial surveillance, I do think that is a pejorative term towards businesses. And I think that you can see that permeates throughout the ANPRM. The word surveillance is mentioned 80 times. And if you look at what the FTC is charged with, they are charged with determining whether practices are unfair, which includes a harm component, but it also includes a benefit component. And if you look at the ANPRM, a lot of the opening discussion is about the harms to consumers, and there's very little discussion of the countervailing benefits. In fact, I think there's one reference to perhaps in theory, there may be some benefits to personalized advertising. So I do think that the FTC needs to be rigorous in trying to figure out both the harm side of the equation and the countervailing benefit side of the equation, because if they don't address the countervailing benefits, I think that the rule could be subject to challenge, and I think will be subject to challenge.
Gabe, thoughts?
Yeah, I put a little bit less stock in the term commercial surveillance, just because the way they define it is actually so broad that it kind of captures what the FTC has already been looking at for years in the privacy and security space. So they're talking about the monetization of data, they're talking about ads, they're talking about collecting data from consumers, and the way they've defined it actually doesn't incorporate any of the definition of surveillance. So I'm not sure that I read that term as having that much weight in terms of where this goes. To me, where the rubber hits the road is what is the actual rule that they're ultimately going to put forward based on this process that they're starting. And one of the features of the MAGMOS process is that starting with this ANPRM, if we're calling it that, the FTC doesn't have to put forward a rule right away. In fact, it consults on broad questions. And these questions sort of tip the hand a little bit as to what they might want to regulate. So we've talked about some of the areas like discrimination, children, advertising. There, a number of questions on those different areas. But we don't know what the ultimate rule they're sort of gearing towards looks like. And that I think will affect, how seriously we need to take this commercial surveillance term. And I think what I would flag on that front, which I think Maneesha was getting to as well, is that they need to move a bit carefully and make sure that the rule does meet that statutory framework for deception, unfairness, and prevalence, because there's past practice here, trying to understand what these terms mean. And there's a risk, I think, that if they move forward too quickly, especially with enforcement powers, we'll see more litigation around the FTC's authority. So at the end of the MAGMOS process, interested parties are able to bring cases in court to challenge the rules before they're even implemented. So that brings in courts in a way that we haven't seen in sort of the adjudication model the FTC has brought forward so far, reviewing what is unfair and deceptive in the privacy space. And even beyond that, if there's new fining authority, companies are more likely to challenge the rules when they're hit with enforcement. And that will, again, bring courts into the mix in a way we haven't seen before. And that risks, not only taking down the rules that get passed through this process, but it could undo some of the norms that the FTC has already built up over its years of adjudications. So, I think the rubber meets the road when we see what the rule looks like. But it certainly seems like this could be quite broad.
Gabe, I just wanted to ask as a follow-up, like for me as a layman or, someone with less expertise and certainly less depth than anyone else on this call, when I saw commercial surveillance, I thought, if nothing else, it was sort of some virtue signaling instead of saying like tracking or excessive collection, the idea that that businesses are surveilling the average citizen. It sort of surveillance has that sort of like pejorative connotation. Do you think there's anything to that?
I think it has that sound, but that's not how they've defined it. So they've defined it as the collection, aggregation, analysis, retention, transfer, or monetization of consumer data and direct derivatives of that information. That's a lot of things, not just what you're describing.
Yeah, so I first want to say I think Maneesha is spot on, and I don't think Gabe would disagree either, that if this is a partisan vote to eventually finalize and officially promulgate this rule, there is it is going to be subject to challenge. It is going to be highly litigated, and given that the composition of the federal appellate system, I would not be surprised at all to see it struck down under kind of major questions doctrine type grounds. So I think that is clear as day that sort of the broader sort of Federalist Society sort of project is incompatible, I think, with the vibe of Chair Khan, and there is going to be kind of a meeting of the minds there eventually. My only I think pushback there is, again, Commissioner Phillips' dissent really made an impact on me, and for me, he basically said my vote was winnable, and there were two things that would have caused me to flip over to voting potentially in favor of something like this, and it was a narrower scope, and it was less pejorative language. And less pejorative language is not a reason that something is either okay for an independent agency to issue regs on or not okay. There's no nice etiquette rule for independent regulatory agencies, right? And whether or not you have two regs that are smaller and sit separately, or one larger reg that combines the two into one bigger bucket, that has nothing to do with whether or not something constitutes a major question for sort of judicial review purposes. So I guess my point is, I think Maneesha, I totally agree that ultimately this will be subject to judicial review, most likely overturned, and Chair Khan will be sort of losing what she views to be sort of a noble cause. I think the only thing I think is that there might be a little bit of cynical posturing here about sort of using sort of major questions doctrine as sort of a Trojan horse to just undermine a chair they don't like.
Okay, we have talked a little bit, we've alluded to some of the major issues, but let's talk a little bit about what the meat is here. I know, Maneesha, you wrote a pretty extensive blog post on this. do you want to get us started on what's at the heart of all of this, and what is the agency really trying to get to at a practical high level?
Yeah, so I think if you look at the 95 questions, and there are 95 questions, I think there's a lot of questions that cover areas that are not particularly surprising. Things like data security, algorithmic discrimination, children and teens, data minimization, purpose limitation, biometrics. So I think a lot of that is things that are not particularly surprising. A couple of things that surprised me. Number one, I think Jason alluded to this at the outset, is that there are not a lot of questions about DSARs, access correction, deletion, et cetera. So that didn't seem to be covered. Another thing that was surprising to me is that even in the children and teen questions, there were a lot of questions that are already covered by the existing COPPA rulemaking that is ongoing. And so that seems to be a much better vehicle to change the rules of the road on children's privacy than this MAG-MOS rulemaking. So I think that was somewhat surprising to me. There's one question that was particularly interesting. It was about acquisitions, reflecting, I think, Chair Khan's interest in the intersection between competition and privacy. And it was about the fact that can certain types of companies, or should certain types of companies, not be allowed to acquire data companies like targeted advertising companies. So I thought that was a particularly surprising question. There were other questions about third-party certification. There was also rhetoric about limits and prohibitions on targeted advertising and on discrimination. So fairly broad brush. Again, if I were kind of still at the FTC advising commissioners, I would suggest kind of on the next round going narrower, because I think this is a large amount of items to chew over. I forgot to mention there's things like content moderation, addiction issues, things that really do go beyond privacy. And so I would advise the commission to really narrow this in a rule. Otherwise, I think it's going to A, be subject to challenge, and B, be impractical to maneuver.
Yeah, and I'm just thinking of companies who are like, hey, we want to weigh in on this, and some poor person who's charged with, can you take these 95 questions and can you send in some really thoughtful answers on all of them? Like, my God. Gabe, your reactions to what the commission's aiming to cover.
Yeah, I picked up on a lot of the same points as Maneesha. This is quite broad. And in fact, I thought as I was reading it the first time that it highlights some of the virtues of this unfair and deceptive prohibition, which sometimes gets derided these days, but it shows how when compared to like more robust statutory schemes like the ADPPA or state privacy laws, we're sort of moving in those directions. But it shows the flexibility of this unfairness and deception analysis, that we can move beyond sort of core fair information principles and start to look at some issues that are adjacent, like Maneesha picked up on, addiction to technology, competition concerns. I think it's a real kind of virtue of this framework that it allows for these broader considerations. I found it hard to understand exactly what the focus is, given the breadth of the questions and what the rule looks like coming out of this. So does this look like an ADPPA just passed as regulations? Or does it look like a set of discrete rules focused on specific areas? Because there do seem to be so many questions about AI and algorithmic decision-making, could we see sort of a set of regulations around that, a set of regulations around children and teens? It's hard to know how the picture fits together at this stage. I was also really interested in some of the questions around cost-benefit analysis. And I think that's where regulations could have a particularly large impact. So as you know, under the unfairness doctrine, in order to bring a claim, the FTC needs to prove that an unfair practice isn't outweighed by countervailing benefits to consumers and competition. And there isn't a lot out there right now around how we quantify those costs and benefits when we're talking about privacy-related practices. So some of the questions talking about how we go about doing that analysis, I think could have really significant impact. So far, in the privacy and security space, we've seen unfairness used primarily around data security, where I think there's quite broad consensus that having bad security and underinvesting in security is bad for consumers. And we've seen academic arguments calling for the use of unfairness to elaborate more robust substantive rules. But the FTC so far has not used unfairness in that way, except in a really small number of privacy cases. So I think understanding how to quantify costs and benefits could really play a role in reviving unfairness doctrine in privacy.
There is certainly debate. Some say, I prefer targeted advertising. I want relevant ads. And some people say, I don't. I saw someone tweet the other day, I'm trying to plan a honeymoon and man, could I use some targeted advertising right now? I thought, oh, well, there's one guy that tech companies love. Okay, so let's just push this forward a little bit. What does this look like in the future? I mean, we're facing a long road ahead of us, right? What do we expect next, and when? Gabe.
So once this ANPR gets ANPRM, sorry, Jason, we're putting the M at the end. Once it gets published in the Federal Register, there will then be 60 days to comment. After that, the FTC will hold public hearings on the issue. They then need to notify Congress before they can propose what the rule would look like, and provide opportunities to comment on those rules. So there's going to be a long period of back and forth around this. And then as we mentioned before, even once the rules get adopted, if they get adopted, they can be challenged in court. So we are definitely looking at a long road ahead, especially given the breadth of some of these questions. Remember, the FTC's authority here is just deception and unfairness. And so every piece of the regulation that they ultimately propose has to tie back to those standards. Deception is often easier. So you can propose transparency regulations that are tied very closely to deception. Where you're talking about consent, as some of the questions get to, that's a bit harder to align with deception authority in the past. And then where you move away from deception, you have to tie it back to unfairness, where there's this cost-benefit analysis. And you can imagine passing rules that affect, the entire digital economy, or almost the entire digital economy. Weighing those costs and benefits is an enormous actuarial challenge. So that's going to take a long time and is going to be very fraught.
Jason, you noted earlier some of Philip's dissent, and as we recently learned, Phillips will be stepping down in not too distant future, to spend time with his family. He noted that some frustration with some of his cohorts being willing to come to the negotiating table. Take what you will from that. Does him stepping down impact this process at all?
I think I would want to defer to the expert on kind of all things FTC on the call, Maneesha. But I think more than anything, it's not so much a procedural hurdle. It's really more of an optics and sort of symbolic sort of hurdle, because this provides an opening for, while the Democrats will still have a 3-seat majority, and they'll be able to have quorum and push things through in the meantime, this opening provides the Republican minority the opportunity to nominate a new commissioner. And while Commissioners Phillips and Wilson are definitely within the core of their kind of base of their party, they have been able to work across party lines from time to time. And so you could see this opening being an opportunity for Republicans to nominate someone that is much more willing to sort of confront Chair Khan sort of in a much more public, much more heated manner, to kind of, essentially give her a taste of her own medicine in their eyes. And that in turn could kind of cause more sand to be sort of tossed around in the policymaking process. I think ultimately though, right, if you're going to have a more divided commission that's generating rulemaking processes that are more likely to get challenged in court and more likely to get overturned, ultimately that means that the federal policymaking process overall is going to move a little bit more slowly probably than we anticipated, and that ultimately pushes momentum back towards states, I think.
Maneesha, your take on Phillips leaving, does it have an impact?
Yeah, so I think Commissioner Phillips has been an incredibly thoughtful commissioner and played the role that a minority commissioner is supposed to play. He has issued some thoughtful dissents, but at the same time, I do feel like when you look at things like cases and enforcement actions, they've largely been 5-0. And so this kind of narrative of kind of a divided commission, I think it comes into play more when we're talking about things like rulemaking. And so I do think that in terms of a privacy rulemaking, given that this is a party line vote, I don't think Commissioner Phillips stepping down is going to make a huge difference. So I do want to go back to conversation or thread from earlier. Gabe was talking about the amount of time it's going to take and the next steps, and I completely agree with that. I think that one of the things that I've heard chatter about is that given the breadth of this ANPRM and really kind of anything could happen, I wouldn't be surprised if the FTC is actually starting to sketch out what an NPRM would look like, given that they know that they're against a clock. So I think that probably is already happening. That's the first point I wanted to make. The second point I wanted to make is that I'm not so sure about unfairness. I think Gabe mentioned that the FTC has widely used unfairness authority in data security cases, and that's certainly true. But I do think if you look at the last several years, I think the FTC has been more and more aggressive, even with both Republican and Democrat votes, in pushing the envelope on unfairness. So for example, the Vizio case, it's unfair to collect and use tracking television viewing behavior without notice and consent. I think that was an unfairness case. There's been cases about using geolocation information without notice and consent that have sounded an unfairness. So I think the FTC has taken steps to say that collection and use of some sensitive data without notice or consent can be an unfair practice. And I think where the FTC has cases, it's on more solid ground in the rulemaking to say that these practices are unfair, because one of the ways in which you can show prevalence of an unfair practice is there have been law enforcement actions about that practice. So I think where there have been law enforcement actions, I think the commission is on more solid ground. But of course, a lot of things in the 95 questions are about areas that have not been the subject of enforcement actions. I think the commission is going to have more of an uphill battle there.
Okay, lastly, before we wrap, naively, I must ask, Gabriel, if the ADPPA actually does make it somewhere, and I know Cantwell is saying don't even think about it, but say it does and a miracle happens, does this rulemaking process matter anymore, or do we cover most of what we want to cover there?
Yeah, it's a great question. I think we don't know exactly what's going to happen and how that plays out. Commissioner Wilson, in her dissent, used the ADPPA as a reason for not supporting this rulemaking initiative, because she pointed to the fact that there's this other process, where legislators are considering these issues on a bipartisan basis. But I don't see an issue with the two proceeding on parallel tracks. Commissioner Bedoya has said that if the ADPPA makes it somewhere and covers the issues he's interested in, then he would vote against having an FTC rule. So we could see it withdrawn. We could also see it scaled back to cover issues that aren't covered within the ADPPA, but are of interest within what the FTC is consulting on. So I think there's room to watch both these processes play out and see where it takes us.
Excellent. Well, thank you all so much for coming and sharing such thoughtful insights. And I learned so much about this process. I'm going to go actually write a blog post based on what y'all, I'm going to steal your thoughts is what I'm going to do. but I'll cite you, I'll quote you, it's okay. Thank you so much for being here, and maybe we'll have another conversation sometime after the FTC can digest thousands of submissions responding to 95 questions apiece. Thanks for being here, everyone. Bye-bye.
Thank you.
Thank you.
Thank you.